Q. Suspensive and resolutory conditions distinguish between the effects of suspensive and resolutory conditions upon an obligation. It is evident that a resolutory condition affects the obligation to which it is attached in a manner which is diametrically opposed to that of a suspensive condition. If the suspensive condition is fulfilled, the obligation arises or becomes effective. If the resolutory condition is fulfilled, the obligation is extinguished. If the first is not fulfilled, the juridical relation is created. If the second is not fulfilled, the juridical relation is consolidated. In other words, in the first, rights are not yet acquired, but there is a hope or expectancy that they will soon be acquired. In the second, rights are already acquired, but subject to the threat of extinction. Miguel's answer, whoever is Miguel. A suspensive condition is a condition imposed upon an obligation and the happening of which gives rise to the demandability of the fulfillment of such obligation. The obligation will only arise upon the fulfillment of the suspensive condition. Resolutory conditions, on the other hand, are conditions that signify the extinguishment of the obligation that is immediately imposed upon the other party. The happening of the resolutory condition ends the obligation of the parties and extinguishes the right of the other party to the prestation agreed upon. Bar Q, 1988. Alternative and facultative obligations. Define alternative and facultative obligations. Alternative obligations refer to those juridical relations which comprehend several objects or prestations which are due, but the payment or performance of one of them would be sufficient. On the other hand, facultative obligations refer to those juridical relations where only one object or prestation has been agreed upon by the parties to the obligation, but the obligor may deliver or render another in substitution. Miguel's answer again. An alternative obligation is one where the debtor is bound by different prestations, but wherein only one is due. It can be performed alternatively, and the performance of one of them is sufficient to extinguish the obligation. A facultative obligation, on the other hand, is one where the debtor is bound to perform one prestation with the right to choose another prestation as substitute. Joint and solidary obligations. Define joint and solidary obligations when there is an occurrence of two or more creditors or two or more debtors in one and the same obligation. Such obligation may be either joint or solidary. A joint obligation may be defined as an obligation where there is a concurrence of several creditors or several debtors, or of several creditors and debtors, by virtue of which each of the creditors has a right to demand, while each of the debtors is bound to render compliance with his proportionate part of the prestation which constitutes the object of the obligation. In other words, each of the creditors is entitled to demand the payment only of a proportionate part of the credit, while each of the debtors is liable for the payment of only a proportionate part of the debt. A solidary obligation, on the other hand, may be defined as an obligation where there is a concurrence of several creditors or several debtors, or of several creditors and debtors, by virtue of which each of the creditors has a right to demand, while each of the debtors is bound to render entire compliance with the prestation which constitutes the object of the obligation. In other words, again, each of the creditors is entitled to demand the payment of the entire credit, while each of the debtors is liable for the payment of the entire debt. How about Miguel's answer? An obligation is joint if there are either two or more, and where the entire obligation is to be paid or performed proportionately by all of the debtors. An obligation is a solidary obligation if each creditor if there are multiple, has the right to demand from any of the debtors the obligation that is due. Well, thanks to Miguel. Q. Solidary obligations. A, B, and C borrowed $12,000 from X. This debt is evidenced by a promissory note wherein the three bound themselves to pay the debt jointly and severally. However, according to the note, A can be compelled to pay only on June 15, 1962. Oh, that's too long. B can be compelled to pay only on June 15, 94, which C can be compelled to pay only on June 15, 1966. On June 15, 1962, X made a demand upon A to pay the entire indebtedness, but the latter paid only $4,000. Subsequently, because of A's refusal to pay the balance, X brought an action against him for collection of the amount. Will such an action prosper? The action will not prosper. It is of course true that the obligation here is solidary and that its solidary character is not destroyed by the fact that the debtors are bound by different periods for payment is expressly provided for in Article 1211 of the Civil Code. However, in solidary obligations of this type, the right of the creditor is limited to the recovery of the amount owed by the debtor whose obligation has already matured, leaving in suspense his right to recover the shares corresponding to the other debtors whose obligations have not yet matured. This restriction upon the creditor's right does not destroy the solidary character of the obligation, because ultimately he can still compel one and the same debtor, if that is his wish, to pay the entire obligation. Therefore, in the instant case, X shall have to wait for June 15, 1964, when B's obligation shall have matured, and for June 15, 1966, when C's obligation shall have matured. On June 15, 1966, he can collect $4,000 from either A or B. On June 15, 1966, he can again collect another $4,000 from either A or B or C. Miguel's answer: the action of X will not prosper. The obligation of A, B, and C is solidary. However, they are bound by different periods, meaning the fulfillment of their obligation is imposed with an agreement of a period on which their obligation will be demandable. The obligation being solidary, X may require payment from any of the debtors. However, as discussed, it is subject to a period, making the choices of X limited to the debtors from whom the obligation is due and demandable. Forms of payment. Under the Civil Code, what are the different special forms of payment? Under the Civil Code, there are actually 4 special forms of payment. They are 1. Application of payment. 2. Dation in payment. 3. Payment by cession. And 4. Tender of payment and consignation. Strictly speaking, however, application of payment by its very nature is not a special form of payment. Miguel's answer: the special forms of payments are Dation in pago, payment by cession, and consignation. Consignation. What are the special requisites of consignation in order that it shall produce the effect of payment? In order that consignation shall produce the effect of payment, it is not only essential that it must conform with all of the requisites of payment, but it is also essential that certain special requirements prescribed by law must be complied with. The debtor must show 1. That there is a debt due, 2. That the consignation has been made either because the creditor to whom the tender of payment was made refused to accept the payment without just cause, or because any of the cause stated by law for effective consignation without previous tender of payment exists. 3. The previous notice of the consignation had been made, given to the persons interested in the fulfillment of the obligations. And 4. That the thing or amount due had been placed at the disposal of judicial authority. 5. That after the consignation had been made, the persons interested in the fulfillment of the obligation had been notified thereof. Miguel's answer: consignation requires that there be an existing valid debt which is due, a prior valid tender of payment, a refusal by the creditor to accept such tender of payment without any valid reason, a prior notice of consignation to the interested parties, the thing due deposited with the court, and another notice to interested parties subsequent to the consignation. Novation. Suppose that under an obligation imposed by a final judgment, the liability of the judgment debtor is to pay the amount of $6,000, but both the judgment debtor and the judgment creditor subsequently entered into a contract, reducing the liability of the former to only $4,000. Is there an implied novation which will have the effect of extinguishing the judgment obligation and creating a modified obligatory relation? Reasons. There is no implied novation in this case. We see no valid objection to the judgment debtor and the judgment creditor in entering into an agreement regarding the monetary obligation of the former under the judgment referred to. The payment by the judgment debtor of the lesser amount of $4,000 accepted by the creditor without any protest or objection and acknowledged by the latter as in full satisfaction of the money judgment, completely extinguished the judgment debt and released the debtor from his pecuniary liability. Novation results in two stipulations: one to extinguish an existing obligation, the other to substitute a new one in its place. Fundamental it is that novation affects a substitution or modification of an obligation by another, or an extinguishment of one obligation by the creation of another. In the case at hand, we fail to see what new or modified obligation arose out of the payment by judgment debtor of the reduced amount of $4,000 to the creditor. Additionally, to sustain novation necessitates that the same be so declared in unequivocal terms, clearly and unmistakably shown by the express agreement of the parties or by acts of equivalent import, or that there is complete and substantial incompatibility between the two obligations. Miguel's answer: there is no implied novation. What is present is a partial remission of $2,000. The amount of $4,000 is still due and demandable. An implied novation is said to have occurred only if there is no declaration that the old obligation is extinguished by the new one, but the old and the new obligations are incompatible and cannot coexist. In this case, the obligations are not incompatible. There is still a debt due, although the amount was reduced. Thank you, Miguel. Q. Merle offered to sell her automobile to Violi for $60,000. After inspecting the automobile, Violi offered to buy it for $50,000. This offer was accepted by Merle. The next day, Merle offered to deliver the automobile, but Violi, being short of funds, secured postponement of the delivery, promising to pay the price upon arrival of the steamer. Helena, the steamer, however, never arrived because it was wrecked by a typhoon and sank somewhere off the coast of Samar. 1. Is there a perfected contract in this case? Why? Number 2. Is the promise to pay made by Violi conditional or with a term? 3. Can Merle compel Violi to pay the purchase price and to accept the automobile? Why? Suggested answer. Number 1. Yes, there is a perfected contract because there is already a concurrence between the offer and the acceptance with respect to the object and the cause which shall constitute the contract. Such concurrence is manifested by the acceptance made by Merle of the offer made by Violi. Number 2. I submit that the promise to pay made by Violi is not conditional, but with a term. The promise is to pay $50,000 upon arrival in this port of the steamer Helena, not if the steamer Helena shall arrive in this port. Hence, the promise is with regard to the date of arrival and not with regard to the fact of arrival. Number 3. Yes, merely can compel Violet to pay the purchase price and to accept the automobile. She will, however, have to wait for the date when the steamer Helena would have arrived, were it not for the shipwreck. After all, there is already a perfected contract. Miguel's answer: yes, there is a perfected contract. Number 1. A contract is deemed perfected upon the concurrence of the essential requisites provided for by Article 1318 of the Civil Code. There is consent, as shown by acceptance of both parties of the offers and counter-offers of one another. There is an object agreed upon, which is the automobile, and a cost, which is the promise to pay by Violet of the amount agreed upon for the automobile. There is a meeting of the minds by the parties upon the object and the cost, therefore, there is already a perfected contract. Number 2. The promise to pay is subject to a term. The stipulation agreed upon by the parties is that payment would be effected upon arrival. Therefore, such is a question of when rather than if. An obligation is subject to a term if the stipulation is certain to happen, and on the other hand, subject to a condition if the stipulation is future and uncertain. In this case, the arrival is sure to happen, thereby making it a question of when rather than if. Number 3. Yes, merely can compel Violet to pay the price and accept the automobile, as there was already a perfected contract. Implied contract and quasi-contract. Distinguish an implied contract from a quasi-contract. Suggested answer: an implied contract requires consent by the parties. A quasi-contract is not predicated on consent, being a unilateral act. The basis of an implied contract is the will of the parties. The basis of a quasi-contract is law, to the end that there be no unjust situation. Miguel's answer: an implied contract is different from a quasi-contract in terms of the presence of consent. In an implied contract, the consent of the parties is present, although it is not expressly given. It is deducible from the conduct of the parties. A quasi-contract, on the other hand, does not require the consent of the parties, but it is an obligation based on equity and ensuring that there be no unjust enrichment between the parties. Dation in payment. What is dation in payment and how it is distinguished from assignment of property? Dation in payment is a special form of payment whereby property is alienated to the creditor in satisfaction of a debt in money. Assignment of property or payment by cession is a special form of payment whereby the debtor cedes or assigns his property to his creditors so that the proceeds thereof will be applied in payment of his debts. Miguel's answer: dation in payment is the alienation by the debtor of property in favor of the creditor for the purpose of satisfying his debt. Dation in payment is different from assignment of property in terms of different factors. In assignment of property, the properties ceded are all properties of the debtor. In dation in payment, what is delivered is only a specific property, which is considered an equivalent of the outstanding monetary obligation of the debtor. In assignment of property, it is necessary that the debtor be in a state of insolvency, while in dation in payment, there is no such requirement. Also, dation in payment is a form of novation of the contract, while assignment is not. Rescission of contracts. X offered to buy the house and lot of Y for $300,000. Since X had only $200,000 in cash at the time, he proposed to pay the balance of $100,000 in 4 equal installments monthly. As the title to the property was to be immediately transferred to the buyer, X, to secure the payment of the balance of purchase price, proposed to constitute a first mortgage on the property in favor of Y. Y agreed to the proposal so that on April 15, 1987, the same contract of sale in favor of X was constituted, and on the same date, X constituted the said first mortgage. When the first installment became due, X defaulted in the payment thereof. Y now brings an action to rescind the contract of sale, which X opposed. How would you decide the conflict Give your reasons. Suggested answer. Why can rescind? Specific performance and rescission are alternative remedies in breach of reciprocal obligation. The contract is only partly consummated. The price is not fully paid. The mortgage is an accessory contract of guarantee and can be waived by the creditor who can avail of his remedies in the principal contract. Miguel's answer. Why cannot rescind? Jurisprudence provides that slight breaches of the contract will not justify rescission. In this case, X can be deemed to have substantially complied with the contract of sale, paying 2/3 of the purchase price. In order to justify rescission, the breach of the contract should be substantial, that it would defeat the object of the parties in entering into the contract. That there is substantial breach cannot be said in this case. Perfection of contract. X came across an advertisement in the Manila Daily Bulletin about the rush sale of 3 slightly used Toyota cars, model 1989, for only $200,000 each. Finding the price to be very cheap, and in order to be sure that he gets 1 unit ahead of the others, X immediately phoned the advertiser Y and placed an order for 1 car. Y accepted the order and promised to deliver the ordered unit on July 15, 1989. On the said date, however, Y did not deliver the unit. X brings the action to compel Y to deliver the unit. Will such an action prosper? The contract in this case has been perfected. However, the contract is unenforceable under the statute of frauds. The action will prosper if there is no objection to the oral evidence, which amounts to a waiver of the statute of fraud. Miguel's answer, yes. The action of X may prosper provided that there be no objection to the oral evidence presented regarding the oral agreement entered into by X and Y. While there is a perfected contract, it is unenforceable for failure to comply with the statute of frauds, because it is an agreement for the sale of goods at a price not less than $500. It is required to be in writing. However, the Civil Code also provides that contracts infringing the statute of frauds may be ratified provided that there be a failure to object to the presentation of oral evidence to prove the same. Estoppel. What do you understand by estoppel? What are the different kinds of estoppel? Explain. The Civil Code enumerates only 3 kinds of estoppel: estoppel in pairs and estoppel by deed. And jurisprudence gives a third, namely estoppel by laches. Estoppel in pace or by conduct arises when one, by his act, representation, oral admission, or by his silence, induces another to believe certain facts to exist, and the other realize an act on such belief. Estoppel by deed is that by virtue of which a party to a deed and his privates are precluded from asserting as against the other party any right or title in derogation of the deed or any fact asserted therein. Miguel's answer. Estoppel is a bar from denying or asserting something to the contrary from that which has already been previously established as the truth by his own representations. The Civil Code classifies estoppel into 2, namely estoppel by deed and estoppel in pace. Estoppel by deed is the kind of estoppel which is in writing, which bars such parties from asserting anything to the contrary of what is in the written document. Estoppel in pace, on the other hand, is estoppel arising from conduct that amounts to a representation of facts. Civil obligation and natural obligation. How is a civil obligation distinguished from a natural obligation? Give an example of a natural obligation. Civil obligations give a right of action to compel their performance. Natural obligations, not being based on positive law, but on equity, but in natural law, do not grant a right of action to enforce their performance, but after voluntary fulfillment by the obligor, they authorize the retention of what has been delivered or rendered by reason thereof. Example of a natural obligation: when a right to sue upon a civil obligation has lapsed by extinctive prescription, The obligor who voluntarily performs the contract cannot recover what he has delivered or the value of the service he has rendered. Miguel's answer: civil obligations are obligations that can be enforced through a civil suit. It is an obligation which gives rise to a cause of action. Natural obligations, on the other hand, are obligations that do not grant a cause of action. It is an obligation that is merely based on equity. An example of a natural obligation is when a third party pays for the debt of another, which the obligor is not legally bound to pay because it has prescribed, but the debtor voluntarily reimburses such third person. The obligor cannot recover what he has paid. 1990. X was the owner of a 10,000 square meter property. X married Y, and out of their union, A, B, and C were born. After the death of Y, X married a Z, and they begot as children D, E, and F. After the death of X, the children of the first and second marriages executed an extrajudicial partition of the aforestated property on May 1st, 1970. D, E, F were given a 1,000 square meter portion of the property. They were minors at the time of the execution of the document. T was 17 years old, E was 14, and F was 12, and they were made to believe by A, B, and C that unless they signed the document, they will not get any share. Z was not present then. In January 1974, D, E, and F filed an action in court to nullify the suit, alleging they discovered the fraud only in 1973. A. Can the minority of D, E, and F be a basis to nullify the partition? Explain your answer. B. How about fraud? Explain your answer. Yes. Letter A. Minority can be a basis to nullify the partition because D, E, and F were not properly represented by their parents or guardians at the time they contracted the extrajudicial partition. Letter B. In the case of fraud, when through insidious words or machinations of one party, the other is induced to enter into the contract without which he would not have agreed to, the actions still prosper because under Article 1391 of the Civil Code, in case of fraud, the action for annulment may be brought within 4 years from the discovery of the fraud. Miguel's answer: A. Yes. Minority can be the basis of nullifying the partition. Minority is one of the restrictions provided for in Civil Code that limits a person's capacity to act or enter into a certain agreement. D, E, and F, not being represented by parents or guardians, can be the basis to nullify the partition. Letter B. If fraud was present, the action will also prosper as fraud is considered as a vitiation of consent, which makes the contract voidable, there being a lack of one of the essential requisites of a contract. Freedom to stipulate. The Japan Airlines JEL, a foreign corporation licensed to do business in the Philippines, executed in Manila a contract of employment with Marites Guapa, under which the latter was hired as a stewardess on the aircraft flying the Manila-Japan-Manila route. The contract specifically provides that 1. The duration of the contract shall be 2 years. 2. Notwithstanding the above duration, JEL may terminate the agreement at any time by giving her notice in writing 10 days in advance. And 3. The contract shall be construed as governed under and by the bylaws of Japan, and only the court in Tokyo, Japan, shall have jurisdiction to consider any matter arising from or relating to the contract. JEL dismissed Marites on the 4th month of her employment without giving her due notice. Marites then filed a complaint with the labor arbiter for reinstatement, back wages, and damages. The lawyer of JEL contends that neither the labor arbiter nor any other agency or court in the Philippines has jurisdiction over the case in view of the above provision 3 of the contract which Marites voluntarily signed. The contract is the law between her and JEL. Decide the issue. Labor legislations are generally intended as expressions of public policy on employer-employee relations. The contract, therefore, between Japan Airlines and Maritas may apply only to the extent that its provisions are not inconsistent with Philippine labor laws intended particularly to protect the employees. Under the circumstances, the dismissal of Maritas without complying with Philippine labor law would be invalid, and any stipulation in the contract to the contrary is considered void. Since the law of the forum in this case is the Philippine law, the issues should be resolved in accordance with Philippine law. Miguel's answer: the lawyer of JEL is wrong. Although the parties have the freedom to stipulate anything they want in the contract, it is still subject to the rule that is not contrary to law, morals, good customs, and public policy. The stipulations in the employment contract must still be in compliance with labor laws in the Philippines, as these labor laws were created in order to protect the rights of laborers in the Philippines. Stipulations violating such is contrary to law and public policy. 1991. Nature of contracts. Obligatoriness. Roland, a basketball star, was under contract for 1 year to play exclusively for Lady Love Incorporated. However, even before the basketball season could open, he was offered a more attractive pay plus fringes benefits by Sweet Taste Incorporated. Roland accepted the offer and transferred to Sweet Taste. Lady Love sues Roland and Sweet Taste for breach of contract. Defendants claim that the restriction to play for Lady Love alone is void, hence unenforceable, as it constitutes an undue interference with the right of Roland to enter into contracts and the impairment of his freedom to play and enjoy basketball. Can Roland be bound by the contract he entered into with Lady Love, or can he disregard the same? Is he liable at all? How about Sweet Taste? Is it liable to Lady Love? Suggested answer: Roland is bound by the contract he entered into with Lady Love, and he cannot disregard the same. Under the principles of obligatoriness of contracts, obligations arising from contracts have the force of law between the parties. Yes, Roland is liable under the contract as far as Lady Love is concerned. He is liable for damages under Article 1170 of the Civil Code, since he contravened the tenor of his obligation. Not being a contracting party, Sweet Taste is not bound by the contract, but it can be held liable under Article 1314. The basis of its liability is not prescribed by contracts, but is founded on quasi-delic, assuming that Sweet Taste knew of the contract. Article 1314 of the Civil Code provides that any third person who induces another to violate his contract shall be liable for damages to the other contracting party. Miguel's answer: Roland is bound by the contract he entered into with Lady Love. Roland's defense is unmeritorious and has no legal basis. Roland is liable for breach of contract for violating his obligation with Lady Love. Sweet Taste can also be held liable for inducing Roland to violate his contract. Ownership. Pablo sold his car to Alfonso, who issued a post-dated check in full payment therefor. Before the maturity of the check, Alfonso sold the car to Gregorio, who later sold it to Gabriel. When presented for payment, the check issued by Alfonso was dishonored by the Joy Bank for the reason that he, Alfonso, had already closed his account even before he issued his check. Pablo sued to recover the car from Gabriel, alleging that he, Pablo, had been unlawfully deprived of it by reason of Alfonso's deception. Will the suit prosper? No, the suit will not prosper because Pablo was not unlawfully deprived of the car, although he was unlawfully deprived of the price. The perfection of the sale and the delivery of the car was enough to allow Alfonso to have a right of ownership over the car, which can be lawfully transferred to Gregorio. Article 559 applies only to a person who is in possession in good faith of the property, and not to the owner thereof. Alfonso, in the problem, was the owner, and hence Gabriel acquired the title to the car. Non-payment of the price in a contract of sale does not render ineffective the obligation to deliver. The obligation to deliver a thing is different from the obligation to pay its price. Miguel's answer: no, the suit will not prosper. Gabriel has the right to the car as he bought it in good faith from Alfonso, who was then its rightful owner. The payment of the price and the delivery of the car was enough to perfect the sale and vest ownership to Alfonso. Pablo's resort would be to sue Alfonso for violation of BP 22 or the bouncing checks law for issuing a check knowing that it has no funds to pay another. Period. Suspensive. In the deed of sale of a realty, it was stipulated that the buyer would construct a commercial building on the lot, while the seller would construct a private passageway bordering the lot. The building was eventually finished, but the seller failed to complete the passageway as some of the squatters, who were already known to be there at the time they entered into the contract, refused to vacate the premises. In fact, prior to its execution, the seller filed ejectment cases against the squatters. The buyer now sues the seller for specific performance with damages. The defense of the obligation to construct the passageway should be with a period which, incidentally, had not been fixed by them. Hence, the need for fixing a judicial period. Will the action for specific performance of the buyer against the seller prosper? No. The action for specific performance filed by the buyer is premature under Article 1197 of the Civil Code. If a period has been fixed, although contemplated by the parties themselves should fix that period, failing in which the court may be asked to fix it, taking into consideration the probable contemplation of the parties. Before the period is fixed, an action for specific performance is premature. It has been held in Borromeo versus CA that the Supreme Court allowed the simultaneous filing of action to fix the probable contemplated period of the parties, where none is fixed in the agreement if this would avoid multiplicity of suits. In addition, technicalities must be subordinated to substantial justice. The action for specific performance will not prosper. The filing of the ejectment suit by the seller was precisely in compliance with his obligations and should not, therefore, be faulted if no decision has not yet been reached by the court on the matter. Miguel's answer: no. The action for specific performance will not prosper, since the period has not been fixed yet. There can be no delay, yet, if there is no period fixing the time when the obligation must be fulfilled. Liability Solidary Obligation. In June 1988, X obtained a loan from A and executed with Y as Solidary co-maker a promissory note in favor of A for the sum of $200,000. The loan was payable at $20,000 with interest monthly within the first week of each month, beginning July 1988 until maturity in April 1989. To secure the payment of the loan, X put up a chattel mortgage on his car, a Toyota Corolla sedan. Because of failure of X and Y to pay the principal amount of the loan, the car was extrajudicially foreclosed. A acquired the car as A's highest bid of $120,000 during the auction sale. After several fruitless letters of demand against X and Y, A sued Y alone for the recovery of $80,000 constituting the deficiency. Y resisted the suit, raising the following defenses: A, that Y should not be liable at all because X was not sued together with Y. B, that the obligation has been paid completely by A's acquisition of the car to Dation in pago, or payment by cession. C, that Y should not be held liable for the deficiency of $80,000 because he was not a co-mortgager in the chattel mortgage of the car, which contract was executed by X alone as owner and mortgager. D, that assuming that Y is liable, he should only pay the proportionate sum of $40,000. Decide each defense with reason. Suggested answer, letter A. This first defense of Y is untenable. Y is still liable as solidary debtor. The creditor may proceed against any of the solidary debtors. The demand against one does not preclude further demand against the other so long as the debt is not fully paid. Letter B. The second defense of Y is untenable. Y is still liable. The chattel mortgage is only given as a security and not as a payment for the debt in case of failure to pay. Y as a solidary co-maker is not relieved of further liability on the mortgage. C. The third defense of Y is untenable. Y is a surety of X, and the extrajudicial demand against the principal debtor is not inconsistent with the judicial demand against the surety. A suretyship may coexist with a mortgage. D. The fourth defense of Y is untenable. Y is liable for the entire prestation since Y incurred a solidary obligation with X. Articles 1207, 1216, 1252, and 2047 Civil Code. Bicol Savings and Loan Associates versus Ginhawa. Miguel's answer. A. Y is wrong. The obligation being solidary, A can demand payment from any of the debtors at whatever amount but not exceeding that which is due and subject to Y's right to reimburse X share in the debt. B. Y is wrong. Obligation has not been extinguished as there is still a deficiency of $80,000 that X and Y must still pay A. The car was merely security provided by them to ensure A that they would pay, but does not equate or amount to Dation en pago or cession, which may extinguish the obligation. C. Y is wrong. Y is still a surety of X and can still be held liable as a surety despite the existence of a mortgage. D. Y is wrong. A can demand the whole $80,000 from any of the debtors, the obligation being solidary. Y cannot be said to be liable for only $40,000 but for the entire amount, subject to his right to get reimbursement from X of his proportionate share. 1993. Extinguishment, loss, impossible service. In 1971, Able Construction Incorporated entered into a contract with Tropical Home Developers, whereby the former would build for the latter the houses within its subdivision. The cost of each house, labor and materials included, was $100,000. 400 units were to be constructed within 5 years. In 1973, Able found that it could no longer continue with the job due to the increase in the price of oil and its derivatives and the concomitant worldwide spiraling of prices of all commodities, including basic raw materials required for the construction of the houses. The cost of development had risen to unanticipated levels and to such a degree that the conditions and factors which formed the original basis of the contract had been totally changed. Able brought suit against Tropical Homes, praying that the court relieve it of its obligation. Is Able Construction entitled to the relief sought? Yes, the Able Construction is entitled to the relief sought under Article 1267 Civil Code. The law provides when the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom, in whole or in part. Miguel's answer. Yes, the court may grant the relief sought by Able Construction. The Civil Code provides that the court may release the obligor from his responsibility when the service has become so difficult that it has gone beyond the expectation of the parties. However, the intention of the parties must still prevail. It is only when the courts deem that the difficulty goes beyond the intention and expectation of the parties that courts may intervene. 1994. Extinguishment, loss. Dino sued Ben for damages because the latter had failed to deliver the antique Mercedes-Benz car Dino had purchased from Ben, which was by agreement due for delivery on December 31, 1993. Ben, in his answer to Dino's complaint, said Dino's claim has no basis for the suit because of the car was being driven to be delivered to Dino on January 1, 1994. A reckless truck driver had rammed into the Mercedes-Benz. The trial court dismissed Dino's complaint, saying Ben's obligation had indeed been extinguished by force majeure. Is the trial court correct? No. Article 1262 Civil Code provides an obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor, and before he has incurred in delay. B. The judgment of the trial court is incorrect. Loss of the thing due to fortuitous events or force majeure is a valid defense For a debtor, only when the debtor has not incurred delay. Extinguishment of liability for fortuitous event requires that the debtor has not yet incurred any delay. In the present case, the debtor was in delay when the car was destroyed on January 1st, 1994, since it was due to be delivered on December 31st, 1993. Article 1262 Civil Code. C. It depends whether or not Ben, the seller, was already in default at the time of the accident, because a demand for him to deliver on due date was not complied with by him. That fact not having given in the problem, the trial court erred in dismissing Dina's complaint. Reason: there is default, making him responsible for fortuitous events, including the assumption of risk of loss. If, on the other hand, Ben was not in default, as no demand has been sent to him prior to the accident, then we must distinguish whether the price has been paid or not. If it has been paid, the suit for damages should prosper, but only to enable the buyer to recover the price paid. It should be noted that Ben, the seller, must bear the loss on the principle of res spirit domino. He cannot be held answerable for damages, as the loss of the car was not imputable to his fault or fraud. In any case, he can recover the value of the car from the party whose negligence caused the accident. If no price has been paid at all, the trial court acted correctly in dismissing the complaint. Miguel's answer: the trial court is wrong. The defense of loss of the thing due to a fortuitous event can only be used if the obligor is not yet in delay. In this case, the car was due to be delivered on December 31, 1993. Ben was already in delay when he lost the car due to the accident. He cannot therefore use the defense of loss due to fortuitous event. 1994. Extinguishment Novation. In 1978, Bobby borrowed $1 million from Tito, payable in 2 years. The loan, which was evidenced by a promissory note, was secured by a mortgage on real property. No action was filed by Tito to collect the loan or to foreclose the mortgage. But in 1991, Bobby, without receiving any amount from Tito, executed another promissory note, which was worded exactly as the 1978 promissory note, except for the date thereof, which was the date of its execution. Can Tito demand payment on the 1991 promissory note in 1994? 2. Can Tito foreclose the real estate mortgage if Bobby fails to make good his obligation under the 1991 promissory note? Yes. Number 1. Tito can demand payment on the 1991 promissory note in 1994. Although the 1978 promissory note for $1 million payable for 2 years later or in 1980 became a natural obligation after the lapse of 10 years. Such natural obligation can be a valid consideration of a novated promissory note dated in 1991 and payable 2 years later or in 1993. All the elements of an implied real novation are present. A. An old valid obligation. B. A new valid obligation. C. Capacity of the parties. D. Animus novendi, or intention to novate. And E. The old and the new obligation should be incompatible with each other on all material points. Article 1292. The two promissory notes cannot stand together. Hence, the period of prescription of 10 years has not yet lapsed. Number 2. No. The mortgage being an accessory contract prescribed with the loan. The novation of the loan, however, did not expressly include the mortgage. Hence, the mortgage is extinguished under Article 1292 of the NCC. The contract has been extinguished by the novation or extinction of the principal obligation insofar as third parties are concerned. Miguel's answer. Number 1. Yes. Tito can demand payment on the 1991 promissory note. The 1978 promissory note can be considered as the last consideration for the new 1991 promissory note, thereby renewing the period of prescription starting from the issuance of the new promissory note. Number 2. No, the mortgage was extinguished when the first promissory note to which it was attached prescribed. mortgage being merely an accessory contract, is extinguished once the contract to which it was attached is extinguished. Rescission of contracts, proper party. In December 1985, Salvador and the Star Semiconductor Company, SSC, executed a deed of conditional sale wherein the former agreed to sell his 2,000 square meter lot in Caina, Rizal, to the latter for the price of $1 million, payable $100,000 down payment, and the balance 60 days after the squatters in the property have been removed. If the squatters are not removed within 6 months, the $100,000 down payment shall be returned by the vendor to the vendee. Salvador filed ejectment suits against the squatters, but in spite of the decisions in his favor, the squatters still would not leave. In August 1986, Salvador offered to return the $100,000 down payment to the vendee on the ground that he is unable to remove the squatters on the property. SSC refused to accept the money and demanded that Salvador execute a deed of absolute sale of the property in its favor, at which time it will pay the balance of the price. Incidentally, the value of the land had doubled by that time. Salvador co-signed the $100,000 in court and filed an action for rescission of the deed of conditional sale, plus damages. Will the action prosper? Explain. No, the action will not prosper. The action for rescission may be brought only by the aggrieved party to the contract. Since it was Salvador who failed to comply with the conditional obligation, he is not the aggrieved party who may file the action for rescission, but the Star Semiconductor Company. The company, however, is not opting to rescind the contract, but has chosen to waive Salvador's compliance with the condition, which it can do under Article 1545, New Civil Code. Miguel's answer. Oh, Miguel has no answer on this. Q. Nature of contracts. Privity of contract. Baldomero leased his house with a telephone to Jose. The lease contract provided that Jose shall pay for all electricity, water, and telephone services in the leased premises during the period of the lease. 6 months later, Jose surreptitiously vacated the premises. He left behind unpaid telephone bills for overseas telephone calls amounting to over 20,000 pesos. Baldomero refused to pay the said bills on the ground that Jose had already substituted him as the customer of the telephone company. The latter maintained that Baldomero remained as his customer as far as their service contract was concerned, notwithstanding the lease contract between Baldomero and Jose. Who is correct, Baldomero or the telephone company? Explain. The telephone company is correct because, as far as it is concerned, the only person it contracted with was Baldomero. The telephone company has no contract with Jose. Baldomero cannot substitute Jose in his stead without the consent of the telephone company. Article 1293 NCC. Baldomero is therefore liable under the contract. Miguel's answer. The telephone company is correct. The telephone company contracted with Baldomero. Jose is not included in that contract. As far as the telephone company is concerned, the obligation to pay the bills lies with Baldomero regardless of whether or not he is the one using it. Baldomero cannot refuse to pay. 1997. Conditional obligations. Promise. In 2 separate documents signed by him, Juan Valentino obligated himself each to Maria and to Perla. Thus, to Maria, my true love, I obligate myself to give you my one and only horse when I feel like it. And to Perla, my true sweetheart, I obligate myself to pay you 500 pesos I owe you when I feel like it. Months passed, but Juan never bothered to make good his promises. Maria and Perla came to consult you on whether or not they could recover on the basis of the foregoing settings. What would your legal advice be? I would advise Maria not to bother running after Juan for the latter to make good his promise. This is because a promise is not an actionable wrong that allows a party to recover, especially when she has not suffered damages resulting from such promise. A promise does not create an obligation on the part of one because it is not something which arises from a contract, law, quasi-contracts, or quasi-delicts. Article 1157. Under Article 1182, one's promise to Maria is void because a conditional obligation depends upon the sole will of the obligor. As regards Perla, the document is an express acknowledgement of a debt, and the promise to pay what he owes her when he feels like it is equivalent to a promise to pay when his means permits him to do so, and is deemed to be one with an indefinite period under Article 1180. Hence, the amount is recoverable after Perla asks the court to set the period as provided by Article 1197, paragraph 2. Miguel's answer: he did not answer. 1998. Liability. Solidary liability. Joey, Jovi, and Jojo are solidary debtors under a loan obligation of $300,000, which has fallen due. The creditor has, however, condoned Jojo's entire share in the debt. Since Jovi has become insolvent, the creditor makes a demand on Joey to pay the debt. Number 1. How much, if any, may Joey be compelled to pay? Number 2. To what extent, if at all, can Jojo be compelled by Joey to contribute to such payment? Suggested answer: 1. Joey can be compelled to pay only the remaining balance of $200,000 in view of the remission of Jojo's share by the creditor. Article 1219. Number 2. Jojo can be compelled by Joey to contribute $50,000. Article 1217, paragraph 3, Civil Code provides, when one of the solidary debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all his co-debtors in proportion to the debt of each. Since the insolvent debtor's share, which Joey paid, was $100,000, and there are only two remaining debtors, namely Joey and Jojo, these two shall share equally the burden of reimbursement. Jojo may thus be compelled by Joey to contribute $50,000. Miguel's answer: Joey can be compelled to pay the remaining demandable debt of $200,000. Since the creditor has condoned Jojo's entire share, the creditor can only demand for the shares of Joey and Jovi. Since the obligation is solidary, Joey can be compelled to pay for the entire remaining balance after subtracting Jojo's share. Number 2. Jojo can be compelled to pay $50,000, which is half of the share of Jovi, a co-debtor, who has become insolvent. The Civil Code provides that when one or more of the solidary co-debtors are insolvent, his share will be borne by his co-debtors. Extinguishment, compensation, set-off banks. X, who has a savings deposit with Y Bank in the sum of $1 million, incurs a loan obligation with the said bank in the sum of $800,000, which has become due. When X tries to withdraw his deposit, Y Bank allows only $200,000 to be withdrawn, less service charges, claiming that compensation has extinguished its obligation under the savings account to the concurrent amount of X debt. X contends that compensation is improper when one of the debts, as here, arises from a contract of deposit. Assuming that the promissory note signed by X to evidence the loan does not provide for compensation between said loan and his savings deposit, who is correct? Y Bank is correct. Article 1287 Civil Code does not apply. All the requisites of Article 1279 Civil Code are present. In the case of Goulas versus PNB, the Supreme Court held, the Civil Code contains provisions regarding compensation or set-off and deposit. These portions of Philippine law provide that compensation shall take place when two persons are reciprocally creditor and debtor of each other. In this connection, it has been held that the relation existing between a depositor and a bank is that of creditor and debtor. As a general rule, A bank has a right of set-off of the deposits in its hands for the payment of any indebtedness to it on the part of a depositor. Hence, compensation took place between the mutual obligations of X and Y bank. Consensual versus real contracts. Kinds of real contracts. Distinguish consensual from real contracts and name at least 4 kinds of real contracts under the present law. Consensual contracts are those which are perfected by mere consent, Article 1315 Civil Code. Real contracts are those which are perfected by the delivery of the object of the obligation, Article 1316 Civil Code. Examples of real contracts are deposit, pledge, comodatum, and simple loan, mutuum. Miguel's answer. Oh, Miguel is back. Consensual contracts are contracts that are perfected by mere consent of the parties. From the moment of consent, the parties are already bound to fulfill the obligation agreed upon. Real contracts, on the other hand, are contracts that are perfected by the delivery of the object. Delivery is required for real contracts to be valid in addition to the presence of the other essential elements of a contract. Examples of real contracts are deposit, pledge, comodatum, and mutuum. Conditional obligations, resolutory condition. In 1997, Manuel bound himself to sell Eva, a house and lot, which is being rented by another person, if Eva passes the 1998 bar examinations. Luckily for Eva, she passed said examinations. A. Suppose Manuel had sold the same house and lot to another before Eva passed the 1998 bar examination. Is such sale valid? Why? B. Assuming that it is Eva who is entitled to buy said house and lot, is she entitled to the rentals collected by Manuel before she passed the 1998 bar examination? Why? A. Yes, the sale to the other person is valid. However, the buyer acquired the property subject to a resolutory condition of Eva passing the 1998 bar examinations. Hence, upon Eva's passing the bar, the rights of the other buyer terminated and Eva acquired ownership of the property. Letter B. Under Article 1164, there is no obligation on the part of Manuel to deliver the fruits, rentals, of the thing until the obligation to deliver the thing arises. As the suspensive condition has not been fulfilled, the obligation to sell does not arise. Miguel's answer, letter A. The sale is valid. If the buyer bought the house and lot in good faith, without knowledge of the obligation of Manuel to Eva, the buyer need not return the property to Eva because he bought it in good faith and for value. If, however, he was made aware of the agreement between Manuel and Eva, he is obliged to return such property as the ownership is subject to the condition of Eva passing the bar. Letter B. No, Eva is not entitled to the rentals of the house and lot prior to her passing the bar examinations. The right to the fruits of the object will only be vested upon the other party once he has the right to demand for the thing that is the object of the contract. Eva only had the right to demand for the house and lot upon the happening of the condition. Therefore, she has no right to demand for the rentals prior to that. Loss of the thing due, force majeure. Christina brought her diamond ring to a jewelry shop for cleaning. The jewelry shop undertook to return the ring by February 1st, 1999. When the said date arrived, the jewelry shop informed Christina that the job was not yet finished. They asked her to return 5 days later. On February 6, 1999, Christina went to the shop to claim the ring, but the ring was stolen by a thief who entered the shop the night before. Christina filed an action for damages against the jewelry shop, which put up the defense of force majeure. Will the action prosper or not? The action will prosper, since the defendant was already in default, not having delivered the ring when delivery was demanded by plaintiff at due date. The defendant is liable for the loss of the thing, and even when the loss was due to force majeure. Miguel's answer, the action will prosper. The defense of force majeure or fortuitous event can be used when there is an unforeseen event that prevents the obligor from performing his obligation. However, the Civil Code provides that for it to be a valid defense, the obligor must not be in default. In this case, since the obligor was already in default, he cannot invoke the defense of fortuity.